The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to the Kansas Supreme Court. Now ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call this morning's docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Friday, May 28th, 2021 consists of one case. Appeal number 121109, Stormont-Vail Healthcare Incorporated versus Harold E. Sievers, Shawnee County, briefs both sides. The appellant has reserved 2 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. For those familiar with the court, you may notice that we have two individuals in black robes who don't usually sit with us. So let me explain that we have Justice Rosen and Justice Standridge who have recused from hearing this case. We're fortunate that we have two district court judges who are willing to sit with us in their place. Judge John Bausch has served since August of 2012 as a district court judge in the 21st Judicial District. The 21st is comprised of the counties of Clay and Riley counties. Judge Kevin O'Grady has served since October of 2012 as a district court judge. So they both took the bench within months of each other. He sits in the 10th Judicial District, which is Johnson County. Judges Bosch and O'Grady have taken time from what I know for both of them is a very busy docket to help us today. And we are very honored that they have done that and want to thank them for their assistance in this matter. Counsel, I would tell you that Judge Bosch and Judge O'Grady, along with the rest of the court, have read the briefs in these cases and are looking forward to your arguments. After oral arguments, our two visiting judges will participate in the court's deliberation and the resolution of this appeal. With that, I would then ask counsel to please enter your appearances.
May it please the court, Zachary King of Butler & Associates for the plaintiff appellee, Stormont-Vail Healthcare, Inc., present and ready for argument.
May it please the court, Paul Shipp for the appellant, Harold Sievers, present and ready for argument.
Thank you, counsel. Mr. Shipp, you may proceed with your argument.
Thank you, Your Honor. The legal issue before the court today is whether the Court of Appeals erred when it held that the wages of the judgment debtor can be garnished once they are deposited or paid into the debtor's bank account. The standard of review in this case is unlimited. And that essentially means that the court has no limit on what it can rule here. There are no questions of fact. The facts in this case are actually entirely undisputed. What we are asking the court to do today is to reverse the Court of Appeals and make a finding or a holding that there is no language in the law that exists that says that wages lose their status as wages or earnings once they are deposited or paid into a debtor's account. To make any other ruling or holding would be to read into the law a rule that does not exist. We ask this court to make a finding or a holding that the statutes are clear and unambiguous and they mean exactly what they say. It is clear and unambiguous that wages or earnings under Article 23 of Chapter 60 are exempt from attachment or garnishment. They cannot be garnished unless the procedure is used in KSA 613507. And if a debt collector wants to garnish wages, they have to follow the procedure that's outlined in KSA 613507. We also ask this court to hold that the statute is clear and unambiguous in KSA 613505, that the only thing that is allowed to be garnished or taken from the debtor under 613505 is something other than earnings. And that 613505 does not grant a court the authority to take anything that is earnings.
Counsel,
Yes.
I'm going to jump in there and just ask, is there a limiting principle on the reasoning that you're employing? In other words, is that earned dollar always an earned dollar, no matter what happens to it? Or does it ever stop being earnings?
And I appreciate the question. And the answer to that is yes, it is earnings. It is earnings under KSA 60-2310, whether it is payable or paid. And again,
so just hypothetically, if it had been direct deposited into one account and then transferred to a savings account, and then taken out of the savings account and put under a mattress in the form of cash, and then redeposited in a checking account, it's still earnings, is your perspective? Because that dollar you can connect the dots all the way back to a paycheck.
Yes, I think that it would be there could potentially be a factual dispute if that were brought up in a court of law, but the structure of the statutes are clear and unambiguous. Under Article 23 of Chapter 60, under 2310, that is a restriction on what a debt collector or a creditor can take from the debtor. Under 60-2310, they can take no more than 25% of the gross, aggregate disposable earnings of the debtor, period. And the only way that they can do that is under KSA 613507. And the statute is clear and unambiguous in 613505 that the only thing that can be taken through a non-wage garnishment is something other than earnings. Inherent in the law and clear and unambiguous in the law is protection of the working person who's living check to check. It's clear that the exempt portion of the debtor's wages or earnings are sacred and protected in the law. In this particular situation, the creditor was allowed to issue a simultaneous wage garnishment and a garnishment of an account for something other than earnings. And what essentially happened is the debtor lost 25% of his wages in his paycheck. At that point, his wages were payable. They were not paid, but they were payable, which is exactly what's defined in KSA 60-2310. And when his employer took out the 25% that the debt collector was entitled to receive, it then paid the debtor. It paid its employee. And we would assert that the employer is in the best position under all circumstances to determine the non-exempt portion that is to be paid to the debt collector, and that the debtor is entitled to the portion of his wages that are protected under the law, and that is the other 75%. And so when the person in this case was at Walmart purchasing something and he realized that his account was frozen and he couldn't finish his purchase, of course that made him alarmed. And so he looked into it, and that's when he discovered the simultaneous non-wage garnishment. And so, Justice Stegall, just to answer your question very specifically, yes, like I said in my opening statement, the only procedure that is allowed under the law for the creditor to garnish the wages of the debtor is through KSA 613507. And so hypothetically, if the creditor did not take advantage of that process, and then the debtor had his entire paycheck paid into his account, whether it be through a check or cash or an ACH deposit, we would assert it doesn't matter, because under Article 23 of Chapter 60, the exemptions section of the statute, wages are exempt, but for the limitation outlined in 602310. And the procedure that's required is in KSA 613507. And I cannot emphasize enough that KSA 613505 is a garnishment of something other than earnings. And for the court to hold that wages lose their status as earnings once they are deposited into the account, it ignores the structure of the statute. It ignores the protections afforded the debtor in the statute, and it makes absolutely meaningless the section of KSA 602310 that holds that wages are protected and exempted whether they are paid or payable, and that the wages of the debtor are payable in the hands of the employer, and they are paid when they're in the hands of the debtor or the employee. The Court of Appeal. Go ahead.
Oh, sorry. I'll let you finish your argument. I didn't mean to cut you off.
No, you're fine. Go ahead.
Okay. So in 3507, the garnishee is necessarily an employer, correct?
Correct.
Okay. So to reach funds in a bank account, we have 3506, correct?
3505.
Well, 3506 is garnishment of funds held by financial institutions.
Right. Yeah, KSA 613505 is for intangibles that could be held by anyone, including financial institutions. It could be it could be any number of it doesn't necessarily have to be a bank. Generally it is, but it is 613505.
So 3506 is a subset of 3505. Is that your argument?
Yes.
Or is it a standalone garnishment provision?
It's a procedure for garnishing something other than wages.
Okay. Okay. And then in terms of a garnishment served on a financial institution, how would they ever have the information to do the exemption calculation? They wouldn't, would they?
The bank would not. And that's why 613507 puts the employer in the best position to determine which portion of the debtor's wages are non-exempt. The bank is not in a position to do that. And that's why it's inherent and clear and unambiguous in the statute that the only proper procedure for getting those wages is through a wage garnishment with the employer. And that's why 100% of all of the wages paid into a debtor's bank account remain exempt under Article 23 of Chapter 60.
And if that financial institution has, let's say there's a balance of $100 in the account, 50 of it came from the earnings of the account holder, and $50 of it came from a graduation gift. And that individual makes a $25 payment and there's $75 left. And then there's an attachment or a garnishment. How do we, in a revolving account like that, how would anybody know what portion of those funds retain the status of earnings as opposed to just other garnishable property once payments are made out of that account?
Okay, and so that would be a factual question, and the burden of proof is always on the debtor. And when a debtor is notified of a bank garnishment or a garnishment for something other than earnings, the debtor is given the opportunity to object to the garnishment of the account. And it's the debtor's burden to show the court that it falls within a proper exemption. It is our argument in this case that the earnings of the debtor are exempt under Article 23 of Chapter 60, and that the only appropriate procedure to get those earnings is through a wage garnishment, and that it is error to find or to rule or to hold that the statute essentially says that wages lose their status as earnings once they are paid to the debtor. The statutes are void. It does not exist. There is no rule in the statute that says that earnings lose their status as earnings once they are paid. Contrary, the clear and unambiguous meaning of the statute is that earnings retain their status as earnings, whether they are paid or whether they are payable. Payable in the hands of the employer and paid in the hands of the debtor, or in the hands of anyone else for that matter, including a bank or financial institution. And if the debtor can prove that those earnings are earnings or wages under Article 23, they're exempt unless the creditor uses the proper procedure under 613507. And that's the clear and unambiguous meaning of this law.
Can you remind us which statutory provision you're relying on for that paid or payable argument?
That is under 602310. And under 602310, there's a definition of earnings under A1. And earnings means compensation paid or payable. And it's our position that they're paid in the hands of the debtor and they're payable in the hands of the employer. And I'm out of time and I want to retain my 2 minutes for rebuttal.
I want to ask you this question. I also want Mr. King to address it because I am trying to just get your view of whether or not your interpretation is necessary so that there isn't a mechanism of an end run around the legislative intent of limiting the amount of earnings that can be garnished from an employer. In other words, is there any other protection if an employer can only take X amount or pull that back out for the due to the garnishment? Is there any other protection so that exemption isn't basically done away with, or that cap is done away with as soon as it hits the bank account? Then the creditor could go ahead and take away that amount that the legislature had said, no, you can't touch this because of its fee and earnings.
Right. And our position, and my answer to that would be under Chapter 60, Article 23, there is a clear and unambiguous restriction. The creditor is only allowed to take the non-exempt portion, which is 25%. And that is all they're allowed to take. And it doesn't matter whether the wages are paid or payable. And again, the only procedure that allows for garnishment of wages is in 613507, period. And that there is no authority in 613505 to allow the garnishment of anything unless it's something other than wages. And that is the clear and unambiguous meaning of the statute. And it's as clear on its face. And to read it otherwise would be to grant an end run around the law, and would be to say that the restrictions that are listed in KSA 60, 2310, to read it any other way would basically render the section on the non-exempt portion and the exempt meaningless, absolutely meaningless. It would render KSA 60, 2310 completely, it reads it entirely out of the law. When the debtor in this case got paid his wages, KSA 60, 2310 was absolutely meaningless. He had no money for anything. He was left penniless. And that is not what the legislature intended.
Counsel, if I may, so is it your argument then under Justice Wall's example, where it's impossible for the bank to figure out what's wages and what's a graduation present, so they essentially freeze all of it? The debtor receives notice, has the burden of proof. It's their responsibility to ask for an evidentiary hearing with the district court to say, now you've got to figure it out and I'll present evidence.
Yes, Your Honor, that is exactly correct. The debtor has the burden of proof to show the district court that it is wages or earnings, and it falls within the exemption in Chapter 60, Article 23. And that is the debtor's burden. The bank is not in a position to figure that out. That is true for every other payment that any debtor might receive. I know that I've had cases, and I have cases on a regular basis, where an individual might be receiving Kansas Public Employee Retirement Systems payments. And those payments are not automatically protected from garnishment like Social Security is. And when we file an objection to a garnishment for those funds, we present evidence to the court that those are Capers funds and they're sacred and protected. And that's exactly what we did in this case. We presented evidence to the court that this was a paycheck and it was his earnings, and it's exempted under Chapter 60, Article 23. And the creditor's attorney already took a whack at it and already got paid the portion that they were entitled to, which is the non-exempt portion that's discussed in 60-2310, and that they are not allowed to double dip and do an end run around the restriction of 60-2310 when they do the bank garnishment for something other than earnings, because it lets them get all of the wages of the debtor and leaves the debtor penniless. And the finding and the ruling and the holding of the Court of Appeals essentially made the restrictions in KSA 60-2310 absolutely meaningless and read into the law a rule that wages lose their status as earnings once they're paid. That doesn't exist. It is not written in the law anywhere. And there's no rational reasoning offered by the Court of Appeals or any other court that's analyzed this case, even tangentially, that makes sense of that and explains how that does not read 60-2310 out of the law entirely.
Other questions? Thank you, Mr. Schiff. Mr. King?
Thank you, Chief Justice, and thank you all for your time here this morning. This court should affirm the lower court decision and find that the exemptions outlined for wages do not apply to funds held by a financial institution. As stated in Ullery versus Othick, when a statute is plain and unambiguous, this court need not speculate about the intent behind the language and should refrain from reading something into the statute that is not readily found. The legislature created KSA 60-734, 60-2310, and 61-3507 to govern the garnishment of wages. In those statutes, the legislature provided for them to attach the non-exempt portion of the judgment debtor's earnings for all pay periods which end while the order is in effect. The exempt portion of wages, generally and including several caveats, is 75% of the employee's net proceeds. The plain language of KSA 61-3505B1 allows attachment through garnishment of all intangible property, funds, credits, or other indebtedness belonging to or owing the judgment debtor other than earnings, which is in the possession or under the control of the garnishee. Earnings are defined as referenced by counsel in 60-2310 as compensation paid or payable for personal services, whether denominated as wages, salary, commission, bonus, or otherwise. The courts in Doman and Adcock stated the court need only to look to the statute to conclude that, irrespective of whether the proceeds lose their character as earnings upon deposit into a bank account, the restrictions in KSA 60-2310 apply only to wages before they are paid to the debtor.
Counsel?
Yes, sir.
How can that be when the statute says paid? I mean, doesn't that just directly contradict the statute?
I don't believe so, Chief or Justice. It's KSA 60-2310 is the wage garnishment statute. And so if you begin there, that we're discussing a wage garnishment and they're defining earnings under the wage garnishment, to me, it makes complete sense that the compensation can only be paid or payable by an employer. If you
right, but paid is a past tense verb. That means that the money already left the employer's hands, doesn't it? What else could it possibly mean?
Well, Judge, today's Friday, so if the office cuts me a check, they compute the withholding, they allow for all of the required withholdings, and they hand me the check. The check has been paid, but that's paid by the employer. If you were to contact any local bank and say, we need you to hold the earnings of this account holder, most banks are going to respond that they have no earnings because that account holder isn't employed there and they don't hold his earnings.
Sure, I understand there's some practical difficulties, but how in the world is that check that you just discussed that got handed to you not still earnings?
Well,
Because it was paid.
and frankly, that's the issue for you all to decide here today. That's what we're taking up. But when it is deposited into a checking account, it's no longer deemed earnings because it was not withheld or payable by the employer. There has to be a distinction, as you indicated earlier, Justice Stegall. How does that fund flow and how long does that fund carry through? If he carries that paycheck and cashes it as his bank, is it still earnings when he puts it in his wallet and is walking around? If he purchases a TV with it and 6 months later returns the TV, does it become earnings again when he gets the money back from refunding the TV? And there's, in my opinion, the reason the legislature divided the two as it did, earnings through employers and other than earnings, including all other funds, they designated it for that reason, that when the employer is paying it, it is earnings. When he deposits the check, cashes the check, spends the check, those are funds, credits, or other indebtedness, such as referred to in financial institutions.
But do you think it was a legislative intent? I mean, really what you can do is never garnish the employer. Just if you have good information on a bank account, you just garnish the bank account and you've circumvented any of the provisions about it, what is that the employer would have to apply, which would have only been a portion of the paycheck. And through the bank, you can get the entire paycheck. Is that consistent with the legislative intent?
I would make 3 points to that, Chief Justice. First, I believe it is. The other states do hold exemptions for bank accounts for earnings. Our legislature has chosen not to do that. Secondly, that the funds have to have a way to be tracked, and the legislature specifically wrote the law. When I issue a garnishment to other than earnings to a financial institution or a bank, under that statute, they're required to withhold 110% of the judgment debt. And so had the legislature intended for that protection to be there, they would not have allowed for withholding 110% of the amount owed on the claim. They would have included those, and clearly they knew those exceptions existed because they included it in the wage garnishment. So this isn't something the legislature didn't consider. They considered it and they included it in the wage garnishment provisions. They just didn't choose to do so in the non-wage garnishment. And Your Honor, when we're collecting on a judgment debt, we have a good faith belief that they hold an account or they're employed there, but that doesn't ensure that they're employed there or that they have an account at that specific bank. They could have terminated. They could not work enough hours to have a withholding. They could be out on COVID leave. They could have the illness preventing work exception. And that's also true in the bank account. The banks recognize that Social Security and disability are exempt, and they answer as such. And so when they receive a garnishment, if there's disability or Social Security funds in the bank, then they answer as such and they don't withhold. But there is no provision for that in the non-wage garnishment to accept out 25% or to accept out 75% as exempt under wages. So
I'm sorry. Go ahead and complete your answer.
So while we have a good faith belief it's there, there is no certainty that we are going to attach wages and those wages are going to satisfy it because he's going to maintain that employment. And conversely, it's the same on the bank account. As a general rule, once a bank account is garnished once, they generally do not remain open because the debtor is now aware that I know where the account is and that I have taken funds from that account. So more often than not, they choose not to apply funds or deposit funds back into that account. In this case, Mr. Sievers had a couple different options. First, Mr. Sievers invited this garnishment. He came to court, he acknowledged the debt, and he invited us to garnish him. Garnish me to the legal amount was his statement, or the maximum amount. At that time, he could have set up a payment plan and avoided all of this. He didn't choose to do that. So under the law, we're allowed to issue 2 garnishments per month. We issued 1 to the wage, 1 to the non-wage, not knowing if either one of them were going to withhold anything. Again, multiple reasons that could have changed. And in the bank account, as one of the justices noted earlier, there are a multitude of things that could be in that account. It could be stimulus funds. It could be tax refunds this time of year. It could be gifts or graduation presents. It could be the sale of real or personal property. And even the court approving.
Counsel,
Yes.
Counsel, is it correct in this case that the record is uncontroverted that the only funds in that specific account were the direct deposit paychecks?
That is correct on the date of garnishment. However, Mr. Sievers cured that by taking cash back when he made ordinary transactions, put that money in a savings envelope at home, and used that money to cover the accounts that were going to be in arrears due to the garnishment. So even
what you're
Mr.
telling me
Sievers
is that,
acknowledged that he could pull money out of that account and redeposit it.
but counsel, what I'm hearing is that you're here arguing that, hey, we knew that was all his pay, we knew it was his paychecks, and we should be able to take all of it. That's how I understand your argument.
Well, legislatively, I argue that we should be able to take all of it. I did not know it was his entire paycheck until he objected and the hearing was held. But again, our position is that it's no longer earnings, it's funds, and the legislature allows us to capture 110% of the judgment amount due and owed.
What then is the meaning of other than earnings, that phrase in 613505?
Well, other than earnings would be all assets owned by Mr. Sievers.
Why did the legislature need that phrase then if they're going to allow you to take earnings?
Well, I believe that's how they distinguish the two. Earnings is garnishments issued to employers, and other than earnings is garnishments issued anywhere else.
How does that apply to most banks? I mean, are you saying that that's intended to direct them only as to their employees? Is that what you're saying?
The wage garnishment?
The 613505. If you garnish my bank account and I'm not an employee, that phrase is meaningless. Is that your view? But if I
Judge,
am an employee, it has meaning?
I believe that 602310 applies to wage garnishment on paid or payable. And so the distinguishment is earnings are paid by the employer, their compensation paid. Other than earnings is the funds, assets, credits that are held by the bank account. And as Justice Stegall pointed out during the first argument, there is no way for the bank to know what those funds are. They don't know if they're commingled. Even the court in Urban found that once they become untraceable or commingled, they can't be protected. And
you earlier answered my question by saying the legislative intent is clear that they didn't intend for this to apply to earnings. And I'm still not clear why they would have said other than earnings if that was clearly their intent, as you suggest.
My position and belief, Judge, is that that was their intent to distinguish between garnishment to employers and garnishment to bank accounts or other individuals holding assets of the judgment debtor. And earnings is defined under the wage garnishment. Earnings are protected by the 75% exemption. Earnings are protected from illness preventing work. None of those protections are put on the bank account. And
Counsel,
yes, sir.
If I want to follow up on the Chief Justice's question and ask what I think she's asking in a slightly different way. Your position is that money in a bank account can never be earnings, correct?
Yes, that's correct, sir.
And so if money in a bank account can never be earnings, why in the world would the legislature in 3505, why in the world would the legislature say accept earnings in 3505 if earnings can never, as a matter of law, be in a bank account?
Well, because Justice Stegall, if you'll turn to 613507, it's order of garnishments, comma, earnings. And there they outline the procedure and the allowable withholdings, the allowable exemptions. And so it's my belief that the distinction is they're distinguishing it from 61-3507 order of garnishment earnings. 3505 is order of garnishment other than earnings. So anywhere else, if it's not going to the employer, it's going to the bank account, it is other than earnings. Because earnings are paid or payable for compensation that can only be performed by an employer. And so if they're no longer earnings, they are what the court or the legislature is referring to, which is the funds, the assets of the judgment debtor held by the bank. And I would point out that if you're going to accept appellant's position on this, and those funds are exempt as the wage garnishment would be, and you brought this up earlier, how do you handle that? Because when funds are derived from a paycheck, how long do they hold their exemption? Is a judgment debtor allowed to amass $50,000 with a 75% exemption so that we're only allowed to capture 12.5 of the 50,000 and he's allowed to sit on 37.5? And in this case, Mr. Sievers applied cash back into that account. So if the funds originated from earnings, were deposited as a cash deposit, do they remain exempt? And Urban, who takes appellant's position in this case, even found that that would be unworkable because they were now commingled or untraceable. And if the 75% exemption is applied, how many days after the pay period? If Mr. Sievers is paid and 25% is withheld from his wages, 75% gets applied to his bank account, a non-wage garnishment is issued to his bank account. Currently, under state law, they are to withhold and freeze the amount in the account at the time that the garnishment is received. That most likely will not coincide with the same date as the paycheck. And so if the 25% or 75% restriction is going to be applied to the funds in the bank account, how does the bank make that determination? Do they go back to the date of the deposit? Is it then their burden to determine that that's a payroll deposit versus some other type of deposit? If they are able to make that, then if they do make that decision and they withhold 25%, treating it as a wage garnishment because the bank is now in the position they've had to deem that earnings, I'm also allowed to issue 2 garnishments per month. So can I then issue a second garnishment to capture now 25% of the remaining 75%? If we're concerned about an end run, there could be an end run under that procedure as well. But the legislature didn't contemplate that, and they didn't include this multi-tier approach. They allowed the judgment creditor to attach 110% of the funds held in the bank institution and 25% to be withheld from wages. And they clearly distinguished between the two and treated the two entirely separately. They had the opportunity to exempt it, and they chose not to do so in this case.
There are other questions.
Can I?
Go ahead.
Oh, go ahead, Justice Miles.
Well, I mean, it seems to me what you're saying is, well, I don't know if it was coincidence or if somebody thought of it that we're having these oral arguments today when a lot of people, Mr. King, as you say, are getting paid. I know I did today. But you're saying that under the law, if the employer hands a paycheck to the employee, that under the law, the legislature protected 75% of the paycheck, so that that employee, he or she would have 75% at least to go out and pay bills. But the same employee today who has an electronic deposit at the end of the day has nothing because you've garnished it all, right? That's what you say the law permits.
That's correct, Justice Biles, but that would take a couple different things. First of all, my garnishment would have to hit on the exact same day that the paycheck was deposited, immediately after the paycheck was deposited, because if they open the envelope this morning at 9 and the check isn't deposited till 2 p.m., they'd withhold nothing if there was nothing in the account. Or in this case, the remaining $75 of the previous paycheck may have been withheld, but they would not have captured anything else. Additionally, Mr. Sievers in this case had a couple different options. He could have had his paycheck put on a debit card rather than deposited to his checking account. And debtors are sophisticated. They're aware when there's a judgment against them. They're often wise not to deposit funds into checking accounts because they know they can be garnished. His second option, if he didn't want the debit card option, is he could have gone to the bank and removed those funds, used money orders to pay his other bills, and those funds wouldn't have been accessible to me had they been removed before my garnishment issued several days after the pay period. And so if Mr. Sievers invites a garnishment and then leaves those funds in his account, then the bank properly withheld the funds in his account.
Counsel, can I just follow up on that then? If your interpretation's not correct and earnings carry over through the direct deposit, a creditor's never going to have the opportunity to obtain the non-exempt portion of those earnings in a financial institution because that financial institution is not the employer of the debtor. Is that correct?
That's correct, Justice Wall.
Contrary.
And so in a different situation, if we have an employee working part-time at Casey's, for example, they may not meet the minimum income withholding. And so there may be nothing withheld from their paycheck, but if we're going to carry the earnings protection over to the bank account, they could have $5,000 sitting in the account. If this protection is going to be applied to the non-wage garnishment, then they would essentially be judgment proof at that point, so long as they didn't meet the minimum threshold for withholding. Because if I've already issued a garnishment to the employer, I would be prevented from doing so to the bank. And so those funds, I would never have the opportunity to determine whether those were deemed exempt or not. And again, I would point out that other states do allow for earnings exceptions and exemptions applied to financial institutions. Our state has chosen not to do so. They were well aware of that opportunity to allow those exemptions because they were dealing with the wage garnishment statutes at the same time.
Any other questions? Thank you, counsel. Mr. Shipp, you reserve 2 minutes.
Thank you, Your Honor. In rebuttal, I want to cite and state very clearly that our legislature has clearly and unambiguously exempted wages under Article 23 of Chapter 60. Article 23 lists all the exemptions. Wages are exempted, period, absolute period, full stop. I might point out to the court that all of the other exemptions listed in the 15 other exemption rules that are listed there, they're not listed under 6135.05, but they remain exempt even after they're paid. Again, Social Security is automatically protected under federal law, but there are other things that are paid to the debtor, including workers' compensation or Kansas Public Employee Retirement Systems payments. Those are exempt from garnishment. And if a garnishment is issued, the debtor has the burden of proof to prove that those items are exempted if they're paid. And if they are paid, then it's hands off. You're not allowed to have it. And the same thing is true with the paycheck. There is nothing in 6135.05 that allows for the taking of earnings, period. The statute is clear and unambiguous. They're only allowed to take something other than earnings. It's kind of like another nail in the coffin of what the argument the creditor is making here. It is clear and unambiguous that the only way to get the wages of the debtor is through a wage garnishment under 6135.07. And if the creditor's attorney does not take advantage of that procedure, then the wages under 602310 are clearly and unambiguously exempted from garnishment. And they're only entitled to the non-exempt portion of the wages, and that is to be determined by the employer before they are paid or deposited to the debtor. And so we ask that you reverse the Court of Appeals and find that to rule any other way would render the restrictions of 602310 meaningless.
Any questions? Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement. Court is now in recess until 11 a.m. this morning.